has a great impact on how those defender services are allocated. So a lot of the issues we'll be discussing today, if you are from a state that has a statewide system and you have an institutional public defender and your office is staffed with lawyers or a combination of staff attorneys and assigned counsel, some of the challenges will be very different than those individuals who are maybe in a smaller jurisdiction, a more rural community, in the high desert where there's a lot of distance and a lot of space, and maybe it's an assigned counsel system. If you notice the slides, there are different public defender entities, or indigent defense, I should say, entities, whether they are state-based public defender offices that are what we call institutional offices, or if your indigent defense system is overseen by a commission, whether it's some kind of oversight, but it may be more county-driven. Those states that have a county-based delivery system, and they're generally made up of smaller county-based public defender offices, or they are very often contract attorneys, which has, in and of itself, very different challenges, and also assigned counsel. And also, I know we have some attorneys on the call who are private counsel, and they are, maybe you are assigned just to a case, individual case, or you might be an assigned counsel who's contracted to serve as a drug court attorney for the whole drug court. So I just want you to know we are looking at that from those perspectives. We're trying to cover our questions with knowing that we have many, many varieties of lawyers. The question is always, what makes a good person a good lawyer to a good fit for drug court? And that is a challenging question. What I will say is that drug court is a place where people should, want to be. It takes a lot of skill. Attorneys should be experienced. It should never be a training ground or, as I say, a resting place for attorneys. There are so many moving parts. There are so many sophisticated complications and ethical dilemmas that can take place that you really do need an experienced attorney to service in this court. If you have that, again, as I said, if you're from a community where there is only one or two attorneys in that area, it may be a challenge. So some of these issues are always challenges in the smaller communities. We want these attorneys to be able to recognize ethical issues and those dilemmas, to understand where the boundaries fall. It's particularly in drug court where we do have this interesting dynamic that's happening in this therapeutic environment. And our judges speak to clients, which is not usual. And so we need to be careful about those boundaries and be able to identify issues that do have ethical dilemmas. We want to be able to identify and to discern between issues that are confidential in nature versus those that are privileged communication. And that is also another area where experience does help us. To be cross-trained in substance use and treatment and mental health, these are also areas with experience helps us to deliver effective representation and to be able to really work as maturely in a collaborative environment where it can sometimes be very contentious and not everything is by consensus, but we have to try to fulfill the not adversarial aspect of the course, but at the same time, we have to zealously and diligently advocate for our clients on a consistent basis.
Let me jump in there for a minute, Yvonne, if I might. Mike Loeffler, just let me say how honored I am that AU invited me and to put me with Yvonne Segars is putting me with the big league hitters. But let me jump in on this slide and say that while everything that Yvonne says is absolutely true, it's not that it can't be done. It is like many things in life. It is what you put into it. If you care, if you're conscientious, and you probably were preaching to the choir because you got on this webinar. But drug court is getting to be like the law. there's no bottom to how much you can read and learn. It wasn't that way when Yvonne and I started back in the old days. We were just kind of making it up as we went along. But now you can read the research, you can read this, you can participate in the standards as they come out. There's so many things to learn, and you can do it. All it takes is a computer screen and the desire to want to be a good drug court attorney, I believe.
I agree, totally. I mean, Mike, you make me think about when we started in drug court in 1996, 97, and many of you on the call may remember when the federal funds were first handed out for these courts. Most drug court attorneys, teams, we were sent to training as a team. You went to planning training, then you went to implementation training, and you came back and did skills-based training. Unfortunately, a lot of those funding opportunities are not available. So I would agree. It is about, if you can, ideally, you want experienced attorneys to go into the court who understand how to negotiate a plea, the value of a case, when to recognize these sophisticated issues. But you're totally right that the training is out there, and just like this, these kind of webinars, and there's many tools on the NADCP website as well that can be helpful to those attorneys that are learning as they go along. Thanks for that.
I think the challenge on that a lot is that the decisions come at you faster. You have these ethical conundrums in your practice. You have to make plea decisions. You have to make decisions, but you have to get discovery. But those things happen faster in a therapeutic court model than they do anywhere else, and you still have the same equal process, due process safeguards to maintain. And so it's much like them speeding up the assembly line at the chocolate factory. You just gotta work faster and just as well, just as good.
So let's talk about the kind of, again, how we deliver those services. May not only will it be driven by the kind of indigent defense system or model that's delivering the services, but also the kind of court model that your jurisdiction is actually utilizing in order to have a drug court, whether it is a pre-plea diversion type court where the client's matter is will probably be dismissed or vacated contingent upon the successful completion of the program, which is great. I think Miami, I don't know if it's still that, but Miami, I believe, was a pre-plea model where everything was totally wiped away at the end, dismissed if you had a successful completion of the program. There are diversions with a stipulation where the client basically stipulates facts or the factual basis is laid out ahead of time at the time that you enter into the program. And then if you successfully complete the program, the stipulation is retracted or the factual basis is retracted and the case is dismissed. If the client fails in that program, then the stipulation, of course, prosecutors will have to then go out and have you put all the facts together. You've already stipulated in advance, and it supports a guilty plea. A pre-adjudication model where you take a plea up front, so to speak, and that plea is held in abeyance while you complete the program. And you are sentenced until you complete it, versus a post-adjudication model, and where the defendant actually pleads at the point that they enter into the program, and is sentenced to a term of, usually it's a probation, and the probation is conditioned upon successful completion of the program. That's how we have it in our state, in New Jersey, where if you fail to complete the program, the sentence is imposed. You also have post-plea probation revocation model, and you have a combination or a mixed model. You were going to talk about the post-plea model, Michael?
Well, I just wanted to put in there that I think, and this is no value judgment if you come from a plea court, but as the data comes in and it shows that this model is heavily weighted cost savings wise and incarceration savings wise to the high risk, higher need offender, we see that the trend is going downward on this slide. In other words, more teams, more jurisdictions are moving to the heavier post-plea model for the simple fact that a lot of high-risk, high-need offenders have a criminal resume that makes the diversion type models politically unpalatable for the judiciary, for the prosecutor's office, et cetera, et cetera. And so I think it's important to just note, while drug court started at the top of the slide in Miami and Oakland and other jurisdictions with plea diversion, now I think that overwhelmingly things are becoming, and again, it's not a value judgment. It's just the more courts are moving towards the post-plea model, where someone is on probation, and if they fail drug court, they're really going to be looking at some time, not just restarting their case. So it's just a historical perspective that I wanted to give them.
Right, but I also think that, for what it's worth, it's really good. I like when you have the opportunity to have a combination or a mixed model, so that the diversion and pre-plea courts were often only offered, the participants were only those people who had very little criminal history, and basically there was a certain safety or comfort level that people felt by admitting certain clients into the program. I think with the post-adjudication and post-plea, the clients tend to have prior records, more serious offenses, and they were early on, it was very, very difficult to get people into the courts that had 5 or 6 or 7 or 8 prior convictions.
Well, and look, if really what we're going to try to do is be honest here and say we're trying to find alternatives to incarceration. You know, those are the people that are on the fast boat to incarceration, and they're the ones we need to divert into programs like these, as long as they're successful and that they fit therapeutically. And so it is a mixed model, especially from a smaller jurisdiction like mine, where to make a real community impact, you need to take probation violators, you need to take first-time offenders, you need to take people on probation, you know, whatever it is, as long as they're high risk and high need, and you can put them together. You know, the combination model is really good, especially for your smaller rural type jurisdictions, I believe. And
I should say that some of the statistics that you're referring to, and I think they're in one of the first best practices that was put out by NADCP, for attorneys that are having a difficult time persuading the prosecutors or judges in their community to let some of these high-risk, high-need people in, that's a good way to, you know, to show that kind of data to those individuals to help their entry, you know, the participants to be allowed into the program. Absolutely. I think this is where defenders are vital. You've got to get prosecutors to see if they don't already. And I think that there's a cogent argument, a very good intellectual argument to be made, and said, hey, if somebody's been to prison 4 times, sending him a 5th time doesn't make any sense. Let's try to do this first, assuming that he has a therapeutic need and can be helped by a therapeutic court model. And you know, we may have to make, as defenders, for example, you know, some concessions in regard to it may be a heavier hand with probation and this, that, and the other thing as otherwise. But the alternative is to do the same thing we've done over and over again and expect a different result, and that's ludicrous. Okay, good. So we're going to touch base now. For those of you who are brand new to drug court, I assume that there might be some people on the call who haven't had any experience. The 10 key components, which were really that these are the cornerstone to drug courts. These are fundamental components of drug court. In fact, the 10 key components these days, I have seen the 10 key components referenced in decisions by some courts. They are, in some states, they are actually integrated into their statute. They are referred to, you know, regularly. And so it's very important to, hopefully, if you have a well-operating drug court, that your judiciary, your criminal justice system adheres to the fidelity of the 10 key components. And I'll just go through them quickly. One, which is to integrate alcohol and other drug treatment services with justice system case processing. We want our clients, participants, to get the services for substance use and abuse and drug treatment as these cases are processing through the system. A long time ago, it was kind of a joke to get drug treatment, but it's available, and that is the goal. Two, which has been there's the one big issue among the 10 key components, to me at least, as defense counsel. Key component number 2 has always been the biggest challenge. The biggest challenge in the room, which is the using non-adversarial approach, and that in and of itself is a term of art, which we'll talk about a little bit later. Using a non-adversarial approach, prosecution and defense counsel promote public safety while protecting participants' due process rights, and how we protect those rights, why we protect those rights, the obligation for not only defense but for the judiciary and for prosecutors to protect the participants' rights through why they are participating in the process. Key component 3, eligible participants are identified early and promptly placed into the program. And this is always a challenge because we know the research has reflected that if you gauge people in treatment quickly at the time of the crisis, and that crisis, by the way, is usually the arrest or the incarceration, that is a critical crisis point where people who want, if they can use the help, and they don't necessarily, being motivated to drug treatment isn't because, you go there just saying like, oh, I can't wait to get to treatment. No, it is like you're motivated there because you're sitting in a holding cell and you don't want to live in this chaotic space. And so we want to identify people quickly. This has always been balanced against for defense counsel to ensure that you have discovery, that you have arrest reports, that if you want to get people into these programs, you want to, if your drug court model requires a plea up front or a pre-adjudication model, they're required to have counsel and to plead guilty and to do so in very quickly. And you need to, one, have the tools that you need so that you can help make those decisions and lead your client to a good outcome and a good decision, but you also need the information. Number 4, drug courts provide that access to a continuum of alcohol and other services related to treatment and rehabilitation. This continuum of services, you have to speak to a drug court not just as what happens in a treatment provider sitting in a circle having treatment and counseling, but that continuum starts along the way, from clean and sober housing to health services to related helping people get jobs and find places to live, child care for participants who have children and aren't able to attend treatment without it. So that continuum of services continues from the beginning all the way to the end, and it's not the job to just shift to probation or to supervision. It is important for defense counsel to advocate for these services for the clients if they see that they are in need of them, and that's part of the advocacy that happens. Key component 5, abstinence is monitored for frequent alcohol and other drug testing. And this is basically, getting your urine dropped randomly, quickly. And in the early days, I used to be so annoyed when my client used to get so many, there was always a cup and an observed observation. In the early days, I was like, why do they have to watch them do that? That's so impolite. Except as I grew older in this business, I wanted my clients to be tested. I needed my clients to be tested. So I don't want my clients to end up back in jail. This is how you keep, by them being forced to randomly give drug and urine monitoring helps keep your client on track. And so it is an essential piece to keeping clients engaged in treatment and a very good motivator for them to know that they're not to know when they're going to be tested, by the way. Randomness is really key to having our clients stay on the straight and narrow. That is part of it. It is very difficult, but attorneys have to, we have to make that paradigm shift because that's what our clients need in order to be successful. Key component 6, the coordinated strategy governs drug court responses to the participant's compliance. That coordinated strategy, I must say, we, as defense counsel, we don't always agree. And yes, I would like for there to be consensus for the team to have a coordinated response whenever there is non-compliance. I think in all the years I've been in drug court, for the most part, we usually do have a very similar viewpoint. There are points of departure where defense counsel does not agree with the direction that maybe the rest of the team is going, but you do try to communicate with your team so that you do have a coordinated strategy. And that requires, in my view, and Mike, you may want to jump in here, my view is that it should be always driven by treatment decisions. And if treatment is really guiding the decision-making as opposed to punitive, punitiveness, I think that it is always better. Michael, do you have a?
Well, punitiveness is only is an afterthought. That is not a goal here, and I want to come back to that a little bit later and not spend a lot of time here. But this is about changing behavior. It's not about punishing someone for doing wrong. If the punishment, it's a byproduct of trying to get them to change their behavior.
Right. Okay. Number 7, ongoing judicial interaction with each court participant is essential. I know that this is why it happens and how it happens. I can't even tell you. If I did, I could probably become a rich woman. But we do know that the interaction that happens between the judges and participants, it is that authority figure for whatever psychological reason that it's very, very is powerful. And at the end, that I think that I don't know where, I know that the research reflected if a judge communicates with somebody for 3 or 4 minutes, or I think 3 minutes is the magic number.
3 minutes.
But it's in 3. But whether it's a minute or 2 minutes, it's really, to me, a level of respect that these participants are clients, are human beings, and that the judges view them as human, and they talk with them, and they ask them how they are doing, and they have an interest in their success. I think it's super powerful, and it is essential to a good functioning court. Monitoring, number 8, monitoring and evaluation measures the achievement of program goals, engage effectiveness. If you have an evaluator, and even if you don't have an evaluator, it's so important to capture information on the success and the achievement of your program, and to gauge how effective your outcomes are. If you're in a small jurisdiction, I would say go find a university who can help you with some research or gathering data, or write a grant. There is money out there for grants to support this type of evaluation in order to really look at your program and say, what are we doing that's working, and what's not. And you can look at everything from the way you enter a program until the end. Number 9, continuing interdisciplinary education promotes effective drug court planning, implementation, and operations. Basically, education, educating your team and what we do, from how we operate, how we implement, to adopting effective best practices and evidence-based approaches, and to making sure that we're doing those things. And 10, when you go into drug court, I think one of the last things I thought that I'd be doing when I started with drug court was going out to churches and helping to lobby for support services from organizations, nonprofits, clean and sober housing, food pantries, health organizations, universities, hospital-based detox programs, community-based, writing grants for, in our state, I wrote a grant and got $250,000 from AmeriCorps for what we ended up calling life skills advocates, and they staffed our drug court. They were assigned to an attorney, and the attorney had a life skills advocate in court to help the participants just do other things, life skills, set up a bank account, help fill out a job application, do a resume. And so there are lots of other responsibilities as a drug court practitioner outside of representing your client that is expected and helps your court to become stronger. And at the end of the day, the stronger the court is, the better it is for your client.
Interestingly enough, I think that, you know, I've likened this to kind of the Bible of drug courts, but it really is, to not be facetious, is you have to follow 10 of the 10 to be a drug court. If you follow 9 or 8 or 6, it's not a drug court. It's drug court. It's something else. And it's important for lawyers to on either side of the on either table in front of the bar, to make sure that we stay cognizant of all of these things and we continue to work them, because although they were made up on the fly, as Yvonne and I have indicated earlier, earlier in our careers, they've all been borne out by research, strangely enough. And underneath every one of these kind of general precepts, there are being built standards by NADCP and other collaborators to make sure that they're put into effect. So this is just not palaver that Yvonne and I are sporting out here. It is something that was luckily developed and also luckily worked, and it's been borne out by research. So keep an eye to that, as sometimes I think even I forget that sometimes I need to look at the program and make sure that we're conforming with all 10 key components.
You took the words out of my mouth, Michael. I was going to say, if you're new to the program, you go back to look at your own program and say, how do we fit in key component number 1 or number 2, 3, and 4? How does my program measure up? And do we have the things in place that satisfy that component? And if so, how do you measure it? How do you measure it? And I think that for every court, depending on the court model, first of all, and then how it fits in. The next slide is, Michael, you're going to say something?
But before you jump in on the next slide, let me jump in before you and say that I'm really honored to be with the other tribes, so to speak, with regard to this presentation. But let me give you some, what I consider wisdom of 20 plus years in the drug court, is that the hardest job is the defense side. Absolutely is. There are so many things to juggle, and it is such a departure from what is normally done. And also government funders, trainers. I helped develop a training program that Yvonne was talking about earlier, and she was integrally involved in that as well. And I was always, and you can bear me out on this, and that's where I'll end, is that I never thought we were servicing the defenders well enough with all the issues that they had. It is a gargantuan task to take this on. Not that it can't be done, but I want to congratulate you all for wanting to do this, because it ain't easy.
It really isn't. And it takes us right to the quote that's on the screen, which is really one of my. This is from the Critical Issues for Defense Attorneys in Drug Court, which I actually had a hand in participating in that document. But the movement in America, arguably no player on the drug court team, be it judge, prosecuting attorney, probation officer, or treatment provider, has struggled more with his or her own identity and often conflicted roles than the defense attorney. And this is really, really so true. And we've had a hard way with this, but I think over the years we've kind of figured out what we need to do, but the challenges are there on a daily basis, and they don't go away. We just continue to understand how to function within this environment. And that's it. These are the kinds of things that we're balancing, and we're on this team. We're supposed to be on this team in a non-adversarial court, but actually we are the only advocate in the room in a way, and that's what we are. The only member of that team that has a legal relationship with a client that is different. And it is one that we have to be concerned about, as we have ethical responsibilities. We have to advocate for our clients. And there are lines that are conferred upon the relationship between defense counsel and their client, which have priority over that relationship as a member or as a part of that team. And it takes precedence over that. Your relationship with an client and your privileged communication, it takes precedence over any of those other competing interests. There are times when, whether it's an issue of confidentiality, which is a little different than a privileged communication, where let's say your client, a member of your client's family tells you that the client suffers from some health issue, and your client has not revealed that to the team. Now, that might be something that is helpful for the team to understand why certain behaviors is going a certain way, but at the end of the day, it's a conversation where you're should be able to have a conversation with the client and make a decision about whether or not you can consent to, with your client, to sharing that information with the team. That might make a world of difference with how that person is treated and or what decisions are being made, or if the issues we're considering are non-compliant, which are really not necessarily intentioned to be non-compliant, but maybe they're related to something else. Ensuring due process has always been one of those areas that we've had to really struggle with. Due process to ensure that our clients are not being denied in their rights, that if their liberty is at stake, that we protect it, and that has to be a priority. How do we do that at the same time not conflicting with our team members who we collaborate with on a day-to-day basis? But I think that it's important for the team to understand that our role is very different. The team must understand that we have the obligation to advocate. The team has to understand that I have an ethical duty that is different from theirs, and rather than believing that the defense attorney is an obstructionist, they understand that the attorney is fulfilling their ethical duties and obligations, and that we're entrusted with that responsibility. We're legally responsible for that. We're ethically obliged to do it, and I think where everyone understands that, they then understand the need for me to tell a judge, I want to put this on the record. I don't agree with the decision you've made, and therefore, because of that, you have to then take a position that's considered a non-adversarial, an adversarial one. But I say it's an advocacy. It's advocacy, but it can be done in a non-adversarial way. Michael, do you want to add to that?
I think you got it all there, Yvonne.
There is a document which you'll see, and on the bottom of the screen there is a link to the drug court. Now, this is a part of these core competencies, and actually when Mike and I were teaching at the skills space, this is the NADCP document. I think it's NADCP, right? Or NDCI. When we were teaching in the skills space session, this is just one of the documents. I just happened to highlight the core competency for defense counsel. This particular document has core competencies for every member of the team. I think it's a very good idea for defense attorneys to get a copy of this and look at the role of every member on the team to make sure that everybody is inside their lane and doing what's expected of them. And the competencies involve what should be happening at the planning process, what happens during the operational aspect of the drug court, and how those things differ. The competencies can range from whether if you're in the planning stages, there's a million things that you have to do in order to plan. I think for planning in general, the most important thing you can do is be in the room, be at the table, be a part of the conversation. And if you're not, then you have to kick the door open and insist that you're a part of the conversation. Well, maybe not kick, push, no kick.
That's not bad. This is a good document. I'm glad Yvonne put this document on there. While it's very wordy, it's a good thing to take with you. They're kind of like stage directions, or just kind of a check off to if you're new and you don't have anybody mentoring you and it's a new court. This would be a good stage direction, or a checklist, if you will, to kind of make sure that you're going in the right direction in your role as defense counsel.
And I think there are 10 competencies. We only have one page here, so I didn't want to include the whole thing, but I just want to direct your attention to it and ask the attorneys to view it and to go through those competencies and review them. There are attorneys who are members who joined drug courts who were created when they weren't even a part of the office or the organization. They walked into an up and running program, and they inherited what they had. And I say to those attorneys too, then if you've inherited a program, there's nothing wrong with going back to look at some of these core competencies to ensure that your team in your court is, adhering to those fundamental, 10 key components and has adopted a lot of the core competencies. Also, it's important that now, as I said earlier, some of the attorneys on this call, you may be the one or two people in your whole county that you're handling everything. You're from a smaller organization, more rural community. I know there are several people on the call from rural counties, and there might not be a deep bench of attorneys in your organization. So the responsibilities I'm going to talk about now might fall on the shoulders of one person. I understand that, but I have broken it apart so that at least in your mind you should try to keep them separate. When you're setting up responsibilities for what the institutional issues should be, and then the responsibilities for the individual representation. For the institutional representation, we're talking about the kinds of procedures and policies and tasks that should be done by the defender, whether it is establishing your MOUs, your memorandums of understanding, creating your policies and procedures for your office. I'm not talking about for the drug court. I mean, and for the drug court, I hope you were at the table when those policies and procedures were being adopted, or if those policies and procedures don't serve you, you should pull out the book and shake it off and ask for a meeting with your judge and your drug court team and say, this particular issue we're having, and bring it to a separate meeting, not your regular staffing, but a point in time where you can sit down and talk about those issues that aren't working. When you're working with all other agencies, what are the relationships? What are the rules? What kinds of agreements have you struck with other organizations? You want to ensure that there's equal access. You want to ensure that you have criteria, objective eligibility criteria, so that there isn't that if an individual fulfills objective criteria, they should be eligible for drug court. Not that it shouldn't be. I've actually seen it, and because I do a lot of traveling around the country, I've actually seen a drug court team have a conversation about they knew the young man's family and their uncle and the kid's uncles, and because of the uncles, they didn't let this kid into drug court. And I was floored by that, because that individual shouldn't have been judged by, it was a very small community, small county, they knew everyone, and because of that, they denied the person access. And it could also be making sure that you're compliant with 42 CFR, the confidentiality law, how you handle those files, where the files are locked up. All of those kinds of issues are done by the institutional representative. It could be the same lawyer, but sometimes it is a manager or the public defender or a program person in the office. And then you have your individual attorney. On the individual side, before we switch slides, I just want to say, individual representation is a little tricky. So if you're the attorney who's in the court, you're the line attorney, you get the client's initial file. You may not be the attorney in drug court, or you might. But a lot of places, what we call the trial counsel, they get that file, and that trial counsel, the person gets arrested, there's an initial appearance, and this happens every day. We look at the file and say, what are we going to do with Yvonne? Is that person a person who's a candidate for drug court? That trial attorney also has to have some level of skill. in understanding their court, in their jurisdictions, how the courts operate. So it's important that the drug court, public defender entity, or the organization generally educates all attorneys in their jurisdiction about how, and including private counsel, by the way, about how these courts operate, so they know if their client would even be a good fit for the court. Drug court is not for everybody. It just isn't. It is intended for people, for a lot of people, for a lot of different reasons, but it's not for everybody. When that initial attorney has that initial interview, they should be looking at the case itself, the underlying case, and just going through a general assessment of this file, no different than any other case. But then it gets an additional screen of whether or not that person is an acceptable candidate, if the case itself is eligible for the drug court, underlying drug court legal criteria, and then to discuss with the client whether or not you should even make a referral. But if you should make a referral, let's just switch slides. When you should make a referral, it goes to whether that is going to go, are you going to keep that file, or does it then get referred to an attorney who handles drug court? Because I have found in my experience that if there's an experienced attorney in the drug court who then basically takes the file in, if you have a deep enough bench, and if you don't, that might be you, but if you do, if that client is eligible legally, you might want to ask immigration questions also, because not everybody, if the client has questions regarding their status, a plea into drug court could affect their ability to become a citizen or other issues, so it may not be a good outcome for them. But if it is a good case, and if it is the client is interested, then it goes to the drug court attorney. And now, let's just assume you have a drug court attorney, but if you are not that, if you don't have another drug court attorney, and if you are that same person, you can just switch chairs, and then you have to go to another level of representation, which is really about what is this drug court, what are the responsibilities, what are the obligations for your clients, to go over every consent. We want to make sure that you're not signing waivers, that you're not waiving your right to counsel. I really urge every attorney to go back and look at their waivers and their consent agreements. What are you signing your client up for? Are you in the early days, and some of those documents are still out there, people would waive their right to counsel. And until actually a lot of the grants that were being awarded, the Justice Department, I guess BJA, became aware of that. And it was, those things were looked at very carefully. You don't waive your right to a hearing if you're going to be terminated. So there are some things you have to be very careful of. You want to know about the confidentiality agreement. You want to explain to your client that they are giving a permission for their personal information of their treatment to be shared with the treatment provider and with the court. And you're allowing those agencies to share information between themselves. And that if you can retract that information, you can retract your consent, but if you do so, you're probably also going to get thrown out of the drug court program. But there are special rules that govern that under 42 CFR. And it is important that a counsel understand the rules of 42 CFR, which are a little detailed, but there's also a special aspect of 42 CFR that is particularly intended to cover drug courts. They should understand about supervision, that they're going to be observed, peeing in a cup on a regular basis, and that it's 24/7, pretty much 24/7 observation. Supervision. And so probation will come knock on your door at 7 o'clock in the morning on Sunday or Saturday night, and that this kind of curfews happen early on, particularly in the early time of treatment, and that our clients should be aware of that none of this should come as a surprise. The eligibility, after you've even cleared the hurdle for whether or not a person is legally eligible, that is, does the client fit the eligibility, whether it's like age, geography, you have to live in the same county, the charges themselves have to fit within a certain hierarchy. There are the next level of questions about clinical. is this person clinically eligible? Is the person, in fact, a substance use abuser, or is the person addicted to drugs? What is their status? Are they eligible for clinically to be treated for substance use and abuse? Whether or not they have mental health disease or disorders, and if so, can they be managed by that treatment provider or the services? Does the county have the resources? Do you have detox, inpatient, outpatient? And if your client is going to be treated and they recommend that it's going to be an inpatient provider that's, 50 miles down the road, then clients need to be aware that those are the possibilities. The rigors of drug court are steep. I don't think that anybody realizes how much and how busy really treatment is. And there's a reason. I mean, I've learned over the years, there's a reason to keep our clients busy, but beyond being busy, it's therapeutic, and down the road, busyness becomes reevaluated. It's not just being busy, but really it becomes therapeutic, and they understand that they're changing who they are, and that in order to do so, they need the therapeutic aspect, which is not just busyness, but it's real work that they have to do in order to succeed through the treatment process, in order to become clean and sober and to maintain their sobriety. Attending staffing is probably the other issue, which we're going to talk a little bit more about. But let's go ahead. Also,
Yvonne, we better get moving with our time if we're going to allow some time for questions.
Yes, we're talking about, then I would say the next slide really talks about screening clients in. I like to say we need to screen clients in, whether it's our history, the prior record. We want to get as many clients into treatment as possible, even if they do have records that would, historically, we would want to exclude them, but I think the research has reflected that even people with serious prior records can do well in the drug court.
You're absolutely correct, and not only that, but violent priors have nothing to do with drug court success. It really is almost an inverse relationship between how criminally involved someone is and how well that they do and the cost savings that result from this. And nobody has that magic 8-ball that she's talking about in this slide. The prosecutor certainly doesn't have it, and I doubt the defense attorney has it either. The closest thing we have is a risk needs assessment, and we want to make sure that our clientele, our participants, are all of similar risk and need profiles, so that they don't catch risk or catch need from somebody who is more problematic. And I think our first goal is kind of like doctors, is to do no harm. So, trying to guess who's going to do well in it is a very, very problematic exercise.
And okay. We've been getting some questions in, and I think now is a good time to address one of them. One of the questions that we had is that if the courts are made post-adjudication, to address some comfort of the DA or the court in letting someone in with a record, does that lead to the court remaining that way despite change in the demographic or the criminal history of those who are coming into the court and in the jurisdiction?
I'm not sure that I understand that, but I think, yeah, if you have a changing target population, and that should all be done, with the agreement of the team and the stakeholders and all such, is that you really have to look at your model and make sure that your model is going to be able to service the change in your target population. And generally speaking, historically, that target population has been moving to the more seriously involved, criminally and drug dependence and addiction as well. And so, I'm not saying what is the right thing to do, but you've got to make sure that the legal status of that person is enough to motivate them to complete the program and change their behavior, so that they no longer recidivate, they're no longer a candidate for prison, whatever the goal of the program is. So yeah, everything is fluid and everything changes, just like it is in any other walk of life, I think.
I agree. I should say that defense counsel really should advocate for broad admission and of those high-risk offenders. And maybe we can post, there's some research that I think it came out last year about the success of those with violent criminal background and how they can succeed.
I concur. You're correct. Not only that, but also non-drug charges, which is something that I forget because we don't tie our admission to what charges they are. But still, a lot of courts are slovenly, chained to it's got to be a simple drug possession charge, and you're letting a lot of people go over the hill on the train to prison if you limit yourself to that.
And there's, I recall, there's also research that reflects that if improper treatment is used on low-level offenders, it can result in increased crime and program failures. So you don't want to treat the wrong population, and you want to give access to those who really do need the treatment and the support.
Correct. Yeah, and that goes back to the do no harm thing. If you put in someone who's got a cold with someone who has smallpox, they're going to get smallpox and forget about their cold. And we've got to be very conscious that our clients don't succumb, or we don't put them in a position for them to succumb to that. That's
right. And this is another reason why there's so many, we can move on, is that while there are lots of courts, especially in some smaller communities, there's nobody in the drug court. They have very little, the programs are very small because they've been cherry picking the people who really don't need all this supervision and attention, and those people then don't even do that well. And so defense counsel are like, well, we don't even want to send anybody to the drug court because they don't succeed, and if they fail, they end up going to jail for a long time, and that doesn't help either. I'm going to go through quickly because I'm going to get some more questions. This slide, I talked a little bit about this, which are, one, you want to ensure that you want to advocate for equal access. If there's anything I always say to defense attorneys when I go places, I always look around and say, who's in your jail? Who's in the jail? If the jail population should look like your drug court population.
Absolutely.
And it's not the reason why. If I go somewhere and I look up the statistics and I see that they have minorities and there's, or whatever the population is in the jail, but then everybody in court is not in the minority or overwhelmingly white folks in court and overwhelmingly people of color in custody, I'm asking the question, why are they not in drug court? And sometimes people, the drug court teams don't really know the answer, and so you have to really look at your criteria to say, is there anything in our criteria that is unintentionally excluding people? For instance, they might exclude people who are quote, gang affiliates. Well, what does that really mean? Does it mean because you have local kids on the block and you all belong to block number 10, does that make you gang members? Or is it about, is there some real long-term history involved that's excluding people? Are you excluding people based on whether or not they have clean and sober housing, or whether or not they have you can't have more than 3 prior records? Well, you know what? There are populations that have tended to be over-policed, and they may have more priors or more charges in their past. And I'm not even about making a judgment on that, but the question is there anything about your eligibility criteria that's excluding a particular population? If so, you should try to figure out what it is and make sure that there's equal access to these courts. We've already talked about legal eligibility.
Those unintended consequences of your eligibility criteria are huge. We tried to at one time restrict people who were within walking distance of the treatment center, and what we were doing was we were restricting access to rural people, which worked against our Native American population, and if you're in Oklahoma, that's not a good thing. And so we were inadvertently excluding people and never meant to. We were trying to design it for success, and we were for those people who were included, but the people we were drawing outside the line, of course, never even got a chance at success. So watch the unintended consequences of those eligibility criteria, and I think that's not to put any more on you guys, but I think that's a huge thing for defense counsel. I think that you should be able to see that first.
That's right. Also, suitability issues, just before we go off that slide, this is another big area I've got to mention, suitability. If the people, your participants, do they have medical issues that keep them, homelessness, sober living, child care, transportation, mobility? I recently saw somebody, I think the idea was talked around whether they could use Uber as a way of transporting people. I hear you guys chuckling out there. But anyway, I mean, it might work. But if they have an Uber account, because the only thing, you know, there's no money transferred, you pick people up. I don't know what Uber drivers would think. But anyway, suitability is a big problem. So we need to make sure that people are suitable also for treatment, whether or not there are other things like if you have your charges were picked up in one county, but you live in another county, should that exclude you? Let's go to the next slide. I'm going to try to race here, Michael. The referral train, it's very important. How do you get into clients into the program? I say take them wherever you can get them. And however the people are referred to drug courts, usually through trial counsel. It might be through your pre-trial disposition court, probation, revocation. The only thing, the real caution here, in my view, is that whoever is talking to your client, we need to be careful that our clients don't have conversations about the underlying case. Which in any way could be used, their conversations can be used against them or incriminating in nature. I mean, but I guess if you have a skilled staff who understands that we're just doing screening and we're not asking any substantive questions related to the underlying charges, then I don't care where, and I think the more you can refer people in. I know in San Diego, I think there are lots of I think with San Diego, they were one of the first drug courts that I was familiar with that used, I think it's the police actually referred right from the street, you know, right from the arrest. Police had the ability to refer people to the program. Next slide. The entry process, again, I think I already talked about this, which is really to make sure that we have your clients fully understand the rigors of the program, the expectations, the demands, the impact on the family, to go through all of these things, the waivers, consents, confidentiality, program rules. By the way, the difference between program rule and treatment provider rule. There are so many people who do not understand the distinction. You get in, you say, oh, well, these are the rules of drug court. Okay, well, drug court says that you have to also successfully, you know, work with and go to treatment every day. But then your treatment provider, which is down the street, around the corner, down the block, they also have a rule in the treatment provider that says you can't take cookies out of the cookie jar. This is a true story. And when my client got a non-compliance for taking cookies out of the cookie jar, I was floored. But it had to do with trust and honesty. And so my client was like put in jail for a weekend. This is early on, for taking cookies out of a cookie jar. Now, it may seem ridiculous, but your clients need to, and you as counsel, you need to know what are those rules at your treatment provider. You need to go to every treatment provider's facility yourself and know where do your clients live, where do you show up every day, what are they expected to do, what kind of resource, what kind of environment are they in, and ask yourself, are you comfortable with your client being in part of that environment? And it should be. And the impact on employment, I think early on people don't know that sometimes the treatment provider will say, you have to quit your job or you can't work. Now that seems almost ridiculous if people are in jail. They're like, I'm trying to make a living. I need an apartment. There are times when my clients have been forced, you know, to go straight into inpatient, which means they could not work. This is a very difficult issue, particularly in this time, you know, when people need to be employed, but that or maybe they'll be in jail. So it's a tough situation. Sanctions and incentives. Can we go there? The next slide, do we talk about that? Staffing. Okay, we'll do that for, we need to get, I don't want to run out of time here. I think for those who, I know I'm feeling really stressed right now. Okay, staffing, you all know, this is what I call this is the room where it happens, right? If you live in New York, there's a play out now called Hamilton. There's a great song in the production called The Room Where It Happens. Well, that's what staffing is. It's the room where it happens. This is where all of the things that we're supposed to be paying attention to, the regular review of our clients' compliance and noncompliance, whether they're doing well in the program. What we need to do is to work with this team, and the issues that we have to address happen during staffing. For the purposes of the court itself, it's when they monitor the treatment providers, you determine what kind of sanctions, you organize events. These are all on this first slide, these are the things, the general purposes that the staffing is intended to do as a general rule. The next slide will show us that then there are responsibilities that the drug court's purpose for the individual participant has to comply. So the teams have to decide on whether or not an individual is in compliance. Do you need to monitor their substance use more often? When are you going to do that? There's going to be a conversation between the client and the court. The probation and supervision will have to give, biweekly reports. Usually it's biweekly when we start, and whether or not they're ready for phase advancement. What kind of resources are they utilizing? Are you going to impose any sanctions? Are you going to award any incentives? This is the conversation that happens on an individual case-by-case basis. As you go through the docket, this happens in staffing. The one caveat for defense counsel, which has always been a very sticky point for us because we're part of this team, but we don't vote. I've taken the position, and I think most of my colleagues have, which is we do not vote against our clients. Does that mean that you can't give your viewpoint? Of course you can. Your colleagues, your team members, they're going to give their views. Lots of teams have this voting, which I think we're really trying to steer away from. And there's certainly nothing wrong with each individual team member giving their perspective, voicing their recommendation, and hopefully you can get to a consensus. But if not, you just don't. The bottom line is that if you don't agree, you have an obligation to your client to voice your opinion why you don't agree, to put forth some alternative recommendation if you can. So if you've talked to probation in advance of the staffing because you've contacted your probation officer, your supervision officer at least a day or two before staffing to find out, hey, how's Johnny doing this week? If you know there's going to be trouble coming down the pike, you should try to prepare for it. So by the time you get to staffing, you have talked to your client, you have at least thought about what the dilemmas are. And this is not, by the way, I'm not trying to coddle my client, but sometimes there are reasons for behavior or noncompliance. And so you don't, at the same time, you don't want to be caught in a position where you're, what's the word I'm looking for, enabling your clients. Remember, our clients are addicts. And they have been addicts, and they're very good at manipulating, and defense counsel cannot be manipulated. But you also have to be able to understand those treatment issues to know what's treatment, what's punishment, and to try to somehow find some way you have to, navigate this minefield of treatment, mental health disease and disorder, and substance abuse at the same time.
Let me throw in here that there's no data that supports this idea of voting as a committee and staffing. There's no data on it anyway, but I would say that my observation has been throughout the country that this is where adversarialness is in a drug court, and you may be advocating an unusual position for being a defense counsel, and I myself have argued to keep someone from being terminated many times because we don't have anything else to do with them. But it remains for the judge in a judicial role to make those decisions, and we give our input just as if we make any other oral argument. It just happens to be that this oral argument is away from our clients as defenders, which is strange enough. But we've got to come up with that coordinated strategy because it's the united front in the courtroom, as Yvonne has alluded to, and not enabling these folks. They'll pick the weak person on the team and try to get behind them and triangulate them against the rest, and that's the reason for that coordinated strategy and non-adversarialness. And this is where it happens. She's right. This is the room where it happens. It's happening.
And I think that it's important as defense counsel that you also know enough about treatment to know that you want your client to succeed. So if I have to have a conversation with my client who has a dirty urine, before I get there, I know that, listen, by them going in for the weekend if there's some sanction, or knowing that they're going to change their modality of treatment, that is, maybe they'll be moving them to an inpatient, and my client doesn't want to go inpatient because he doesn't want to leave his or her home. We have to, help them appreciate what they need to do to succeed, to get through, because we don't want them to end up in prison. And so we have to have them sometimes get to that point, and they can trust you, but they should be able to trust that, one, you're going to keep them informed. And this is the other point I should have made earlier, that in communicating with your client is critical. In communicating what will happen, how to communicate themselves. And when they're in that room, when we're in staffing, they're not in the room. They're not present. You are their voice. You're their only voice. You are their advocate, and you have to advocate for them. And sometimes advocating for them, you need to have had a conversation with your client to say, unless you help yourself, you know, this treatment isn't going to work without you being a part of this program. Next slide, sanctions and incentives. Mike, go ahead.
Let me take about 4 minutes and talk about incentives and sanctions, and I'll turn it back to you, Yvonne. What I want to try to give you all an idea of, and there's going to be some strange things that I say as coming from a prosecutor in the following 2 or 3 minutes, but incentives and sanctions are not about punishing people. It is not about holding people accountable necessarily. It is about changing their behavior. It is all about changing their behavior. If their behavior was acceptable, they wouldn't be in front of us. They wouldn't have you as a lawyer, me as a prosecutor, et cetera, et cetera. And we know from decades, going back to the 1940s of human behavioral research, how to change behaviors. And if you've ever had a child and raised them to an adulthood, and Yvonne and I have raised all our children to adulthood very successfully, I'd say, both of us, you learn some things. And it's the same thing with dealing with these. This is not to make them metaphorically children. That's not what I'm saying. But changing their behaviors is very much like parenting. And the first thing that we've talked about is once you decide that it's about changing behavior and not making us feel good. You know, if he's positive for meth the 3rd week in a row, it's human nature to say, well, let's lower the boom on him. But if you've already lowered the boom on him twice, you got to think about, well, that's not changing his behavior. Let's back up and see what we need to do to change his behavior, because he's an individual and respond to different things. So algorithms are bad. And what algorithms are, and I'm going to talk about response costs in a minute, is an algorithm is your first dirty test gets you a night in jail. Your second dirty test gets you 2 days in jail. It is for infraction Y, you get response X. For doing something good, A, you get response B as an incentive. The problem is that if you're not afraid of the corresponding incentive, or if you're not motivated by the corresponding incentive or deterred by the corresponding response costs in your algorithm, you're wasting your time. And so we find that an a la carte menu, a selection of things that can be deployed against a non-compliant behavior, that is a sanction, or can be deployed in response to a compliant behavior, that is an incentive, is the best thing to do. Because, for example, you know, my 2 children raised in the same home, same parents, biological, grew up in the same space, basically at the same time. Very different how you get to change their behavior, and so it is that our participants are as well. And I would challenge you as kind of defenders, you know what could motivate this person, because until they've been in probation for a long time, until they've been in treatment for a long time, the person that knows them best probably in the court system is you. And so we have all got to participate in that coordinated response in that room that Yvonne called staffing. So basically, you know, formulas are bad. Menus that you can pick from to try to motivate people are good. And remember, it is not about us at all. It is about them. And it's about getting them to change their behavior, become pro-social, become non-using, and the other things that are our goals. And we'll talk a little bit about. Go ahead. Sorry.
No, I was going to say, and that individualized treatment that is very strength-based, because it is so individual. Right,
and punishment is in the eyes of the behavior. Remember, if I sent my son to his room to think about his transgressions, he's going to be happy because he's got his Xbox, he's got his TV, he's got his stereo, et cetera, et cetera. That's not how you motivate that person. That would not be punishment in the eyes of that behavior. And we've always got to think about it not through our eyes, what's reasonable to us, or what is reasonable to the person that's in front of us. All right, next slide, please. And in that regard, we'll talk a little bit about terminology. And here I just want to try to give you a sample of the different kinds of sanctions and incentives that we can give. And we are very clear on which one of these quadrants, punishment, right? Because that's what we do in the criminal justice system. That's what we're best at. And there is nothing wrong with a night in jail to change somebody's behavior. But here's one of those things that you'll be surprised for me to say. incarceration is not really a huge motivator for a lot of people, especially the higher risk, higher needs people. They've been jail. They know jail. And there's data that says that if you use more than 3 days incarceration at a time, it mutes the effect of the punishment. And after you go past 5 days at a stretch, you become counterproductive. And so that tells me we've got to find other things to motivate it and motivate people. And the reason is that what motivates people more than punishment is, of course, positive reinforcement, a pat on the back, the incentive. That's what's the big thing that you can use to motivate people. Find things that they do right. Catch them doing something right instead of catching them doing something wrong, which is what we've historically tried to do with probation. But in addition to being more effective positive reinforcement than punishment, so is negative reinforcement. So Yvonne has tested positive for her drug of choice. So her first test, we're going to, Yvonne, we will give you a night in jail. But you know what? If you're perfect and stay clean until our next court appearance in 10 days, we'll take that weekend away. That is more powerful than punishment. It gives somebody something to work for, and that's human nature. They're more likely to be motivated than that. And finally, the response cost, and this is the least likely to change behavior of the 4 types of behavioral change, and that is the same old thing. If you do X, you'll get Y. And I'll give the example that if you know your first positive test is going to be an overnight in jail and you've done a third of your life in jail, all they have to do is, when they're thinking about using, is, well, can I do a night in jail? There's no uncertainty there. There's nothing for them to work for to stay clean. There's none of those other things that we've talked about. So be very, very aware of the response costs. And if you have one of these algorithms, I challenge you as defense counsel to go back to your team and say, hey, you know what, this is not the state of the art. This is problematic. We need to think about this on an individual basis like we think of treatment plans as individuals. We shouldn't employ sanctions and incentives mathematically any more than we should just foist some treatment plan on somebody just because they happen to be in drug court. And the last thing that I want to leave you with on sanctions and incentives are these things, and you should always check for these. And the first is to make sure that it's certain. In other words, there is a 1-to-1 ratio. And by that I mean there should be an incentive for every compliant thing that they do. There should be a sanction for every non-compliant thing that they do. That's a 1-to-1 ratio. That's almost impossible to effectuate. But you've got to try. You've got to make that ratio as low as possible. And to go back to raising children, you know, you always compliment them as quickly as you can, as often as you can when they do something well. And you make certain if they are non-compliant that there is a response to that. And if you let that go, you let that go, you let that go, you're really enabling your child and teaching them that it doesn't matter whether they're compliant or not. The immediacy or the celerity means that the response has to be as immediate after the compliant or non-compliant event as possible. This is the reason that you don't, you know, rub your puppy's nose in the wet spot on the carpet 3 days afterwards, because they don't make that that intellectual leap. If you, for example, if you're a participant and you have a non-compliant event, you test dirty, but then you make every treatment for 14 days in a row and you stay clean, and then you're sanctioned, well, that kind of becomes like the puppy. Are you being sanctioned for the good things you've done since the bad thing or for the bad thing? That's very problematic. So the immediacy of the response, be it good or bad, sanction and incentive, is hugely important as well. The magnitude must be equivalent. Being positive for a week doesn't get you a free TV. That would be an external motivation that you will not get all your life, and so we can't do that. Likewise, a positive drug test shouldn't get you 10 days in jail. That doesn't make sense. That's that research that I'm telling you, that there must be a magnitude problem of somewhat equivalency between the non-compliant event and the sanction, between the compliant event and the incentive. This is not really for us, but it is for us to kind of guard, is these incentives and sanctions must be delivered effectively. That's the bedside manner, and this is typically delivered by the judge, of course. But it can't be harmful, it can't be injurious, it can't be humiliating. That is counterproductive. If you do that, then people will become resistant. They'll do exactly the opposite of what you want them to do, Think of a prisoner of war, for example, the terrible things that they would go through. That becomes almost motivational to them to resist. And so we have to be careful when these coordinated strategies that our judge delivers these in an effective manner that explains to them why Yvonne gets a different sanction than Mike does, because while the infraction may be the same, we're very, very different people and respond to things differently. And finally, it must be just fair overall. And fair by, if you're sanctioning for something, you better be darn sure that they did that, that infraction. If you're incentivizing something, you better be darn sure that those people did the compliant event. You must have good, intelligence in that reason, or in that respect. So that's kind of being substantively fair. That's the magnitude, for example, is to make sure it's just fair. But finally, and I'm going to lead into the last thing in our presentation, I think, is the procedural. Again, something strange for a prosecutor to say, but if you're taking away liberty rights, if you're taking away property rights, which is what you're doing with sanctions a lot of times, and I would, again, challenge you to find other things that don't do those things before you resort to them. But there needs to be a fail-safe. There needs to be a way to contest that. It may not be used frequently, but if someone has really been delivered an unfair sanction, particularly, there needs to be some kind of ability, a backdoor, if you will, to have an adversarial proceeding outside the presence of everybody else, where we put on the record, Judge, this is injurious, this is humiliating, this is not the right thing to do, et cetera, et cetera. And we've been shown, although some states are want to provide this, that those programs that have those backdoors for procedural review of sanctions especially work better. And I think it is because, I don't know why, but I think it's because it has a appearance of fairness that maybe another court does not. So not only do they have to be fair sanctions and incentives, there has to be some way to contest those on the rare occasion when that is necessary as well.
So before we do this, I know, I think we have some questions, and I'm worried we're going to be totally out of time. Do you want to give any of those questions now before we just wrap up?
Yes, I think that's a great idea. And also, I'd like to just encourage everyone, we're going to try to get to as many questions as we can. We understand that some people need to, head back to the rest of their day. But if we don't get to your question, or if you have a question that you haven't had a chance to ask or doesn't get answered, please email us at justice@american.edu, and we will be sure to address all of your questions. So the first question I'm going to ask is somebody said, we have a new program where the local public defenders are concerned about a program coordinator conducting a screening interview without the public defender present. And the concern is that the public defender is worried that the defendant might reveal information that might compromise the public defender's ability to protect their client's best interests. And can you speak to that?
I would say two things. One, you create a memorandum of understanding that says that you actually protect anything that your client might say, which we don't want them to talk about in the first place. So if you have the proper form that's only asking objective questions, there's no reason for the treatment screener to go into the underlying crime. You want to know, is the person using and abusing substances? What does their prior record reflect? There should be no reason for them to do that. But if the client should say something that's, quote, incriminating, you should have an agreement that nothing that's said to that screener can ever be used against them, period, end of story.
She is absolutely correct, but let me lay your mind at ease. I've been doing this for 21 years now, and that has never become a problem. And I think it's never a problem because we have the MOU. But it is something that new programs always argue about. But it's much ado about nothing. It very rarely comes to fore, which is not to say you don't have those MOUs, as Yvonne suggests. Absolutely, you should. But it's not the bugaboo you think it's going to be.
Right, and I think lots of times those screeners, right now, lots and lots of programs who does the screening for whether or not they're even eligible for a public defender. Usually it's the court. or some criminal division manager who's screening an individual to see if they're eligible for public defender services. Any of those days, some conversations, could be had. But I think that you have to direct them as to where you want them, and that they really should not be asked about the underlying charge, actually, in any way.
Great. Yes, the next question we have is, how can defense counsel address prosecutors who simply will not agree to allow anyone on their caseload entry into the drug court?
Oh gosh, this is talk to your brethren, Mike.
Let me first say that there are unreasonable people on both sides of the aisle in both cases. That just goes without saying, and that is and number one. Number two, that is an old school belief of prosecutors that is passing by the wayside, and it's passing by the wayside because of education, because of research and training, and try to encourage those things. Try to get some technical assistance, somebody to come in to talk to the team, in air quotes, and really be talking to the prosecutor. At the end of the day, sometimes you just have to wait for a new prosecutor, and I understand that. But I think appealing to but I really think that's old school. It's like believing in not understanding where the sun goes at night. Eventually that knowledge is going to get out, and that's going to go away and not be a problem.
The technical assistance, seriously, is a good idea. What you could do is ask your court or your supervisor to, if they'd be willing to accept technical assistance, and then they send out a team like me and Mike and me, and we go and we actually do training. And while we're training, you don't, jump with 2 feet on top of the prosecutor, but you do ask them about their procedures and their policies, and then hopefully they get the opportunity to talk with somebody like Mike Loeffler so that they get to change their perspective. Also, there are, I would get a hold of the drug court judicial bench book, which was done by Judge Myers, who was one of the authors of that, and give it to them as printed out, put a bow on it, and give it to the prosecutor. Because it really does have a lot of good information. And the other thing is data. Data drives things. When you start looking at statistics and some of the successful programs, when you see the numbers in terms of recidivism, the rate of recidivism, the low rate of recidivism, at some level that, and also whether those people have prior records, it can help. Next question.
That's very good.
Great. So we have a question that says, are drug courts allowing participants in who may suffer from a medical condition that is being treated with narcotic medications? The example that's given is chronic back problems.
Well, so that's a little tricky. Now, this also raises the issue of drug courts that use they use methadone and things of that sort, because some drug courts allow nothing. You can't be on any other drug. And so it really is this is kind of a big problem. I know a lot of courts that won't allow you in if you're on other kinds of medication like that. And I don't know what the real solution is other than, I don't know. What do you say, Mike? It's a real problem.
I feel very, very strongly that we are not doctors. We can't unprescribe things any more than we can prescribe things for doctors. If they need pain management, or if they need methadone or they need Vivitrol, et cetera, who are we to say you can't do that? And we certainly don't want to penalize people for that. Sometimes that may be so significant that they aren't suitable for the program, but generally speaking, I think we have to work around it. And we need to be knowledgeable about what is, what is pain management and what is, just a drug dealer with a pharmacy sign out in front of them.
Right, with the code.
And it's like Yvonne says, it's a sticky wicket, but with the progression from addiction to opioid pain medication going to heroin, et cetera, we've got to intercede in that somehow.
And also,
go ahead. I'm sorry.
I'm sorry. I was going to say, you just reminded me that there are some programs, I think you can lose federal dollars by not allowing certain, I'm almost certain that something came out under the Obama administration related to federal dollars and denying people methods.
Well, you'll never get a grant, or you'll never get, you've got to certify in there that you don't do that sort of thing. But the truth is that kind of started with the methadone movement, where judges were saying you can't use methadone, and in some there were a couple people that lost their lives over that, and that's where that whole thing comes from. You know, I'm a lawyer. I think I'm a damn good lawyer. I might even say I'm better than Yvonne. I'd probably be wrong, but I'm no doctor. I can't say, you know, I can't say, well, he doesn't need opioids. He can just take some ibuprofen and he'll be all fine. And that may be so bad that, you know, you don't get to come into our program. But you know what? If you're in the program and you need it, you got to be able to do it, and we got to figure out a way to treat you and deal with you and change your behavior otherwise. Does that make sense?
This is Carolyn. I just wanted to add that my experience is that in these situations, what judges are doing is, if there's a question, asking the doctor if there's any other options, and if they're not, I mean, putting the doctor on the, on the at the point of decision making. If this is the only thing that is going to work for this person, then they have to defer to what the doctor's recommendation is.
I mean, listen, there's also areas, we know in drug court, you can't even take, you know, NyQuil. You can't take drugs. You can't, you know, it's zero tolerance. So, but I agree that if you're under a doctor's care, it may be different. Also, this crosses into one other area I'm going to bring up, which is for mental health disorders. People who are taking medications for depression, anxiety, and other kinds of things that have to do with their mental health condition, which is another area where we've seen a very conservative, sometimes not a good decision to allow people in because they're suffering from underlying mental health disease and disorder. But we know that something like 70%, by the way, of, I think it's women, 70% of all women in custody who were there for nonviolent offenses had underlying mental health or disorders and disease. I think that's the statistic. If we look at last month's webinar, those statistics we put online, I don't remember them off the top of my head, but the numbers are astounding. The correlation between mental health disorders and underlying diseases, and the need for them to also have medication. So I think that this is a real important issue, and I agree with Mike that you have to use your experts and get your doctors to, you know, support you in what you need, and let it be a decision driven by the professional need and not by our fear.
And that's not to say that you don't send them back to their doctor with a note, say, hey, this person has been diagnosed with substance abuse disorder and they're in a criminal justice program, a drug court program, et cetera, et cetera. Just want you to be informed. And sometimes you'll see the doctors will then change their behavior as well.
Or change medication. They may change medication.
Yeah, that's what I mean by changing their medication. All of a sudden, they do end up with ibuprofen instead of Vicodin or whatever the case may be. And because they've been alerted to something that they hadn't been alerted to before. So there are ways to work around it. That's a training in and of itself.
That's true. Let me just speed through this last slide, and then we can just take the last two questions. Due process protections. That we want to make sure that our clients, that we're protecting their due process rights. Being non-adversarial does not mean that we don't, that we give up our obligations to protect our clients' rights. And we talked about key component number 2 already. I love this. This is from Judge Myers. This is in his judicial book. He says the best practice is to apply probation revocation standards of due process for drug court termination. We should, if we know that our client is going to be terminated or they move to terminate your client from drug court, you have to do all that you can to protect their due process rights by having a hearing, by whatever your law allows in your state, and that's really what guides the way. what liberty interests that are at stake, whether it's, you're being incarcerated or you're losing money or things of that sort, the sanctions that are imposed, especially when there's jail. I mean, sometimes even the imposition of a sanction is something that you have to contest if you believe that your client shouldn't be, and some sanctions can be very severe, and if you believe that you have a basis to contest it, although it's not comfortable for some drug courts, and I think even attorneys have figured out that if you have a dispute with a treatment provider, particularly if it's the only treatment provider in town, and you believe that maybe there should be something different happening, it can be very awkward. But you really don't, but hopefully people still do understand that you have an obligation to protect your client's rights. But at those times, now some people have taken the option that if you have to go into a contested hearing, you step out of the case and you may give this, another attorney may come in. I particularly think that defense counsel who has been with this file, because I believe in the vertical representation, that you represent people all the way through, that you're the best person to represent your client because you have been in the room, you have been at every staffing. I hope you've been at every staffing, and I do mean that I know that there are certain attorneys on the call who say, with Segars, I can't get to every staffing. We don't have an office big enough, or we don't have enough, we don't have the time. I really have to believe that the courts have to work with defense counsel because you do need to be in the room, that the things that the little foxes that get our clients in trouble are the things that happen when we're not there. It is the drip, 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 and then suddenly there's a faucet open and you're flooded and your client's being rushed out of the program, and it's because all the little things that needed to be tended to along the way. If there's a revocation of probation, you have to have the right to counsel. They require notice. You have to know what the notice, the infractions are. It has to be on the record. You have to make a record. You have the right to cross-examine. And the rules are now, this is a couple of cases that say you should have a neutral magistrate. My experience has been give the defense, to your client, the choice. And whenever my clients have had a choice to stay with a drug court lawyer or judge or go back to their trial court, they pick the drug court judge. I've never had anybody ask to go back to the regular court stream, even when they know that there is a contested hearing and they don't agree. Mike, do you want to add anything?
Well, that's interesting because this is probably not the place or the forum for it, but, the states vary widely in what they say you're entitled to upon your termination from drug court. Oklahoma says she has the choice, is what Yvonne says. There are states where you don't have a choice. It goes to a non-drug court judge. There are states that say it doesn't matter. There are states that say that it stays in the drug court alone. He knows the best or she knows the best. So that's all over the board, and there's going to be 15 or 20 answers in the 50 states, but just know what your answer is. And I really truly believe we need to come around to a fairly national standard of you have that choice, as Yvonne states. I'm not sure that it's wise to stay with the drug court judge, but be that as it may, I think they need to have that choice, which is known as the Oklahoma rule, interestingly enough.
Is there another question?
Yeah, so we have two more questions that we should try to answer now. The first is kind of a series of questions related to the different models, pre-plea, post-plea, et cetera. First, a participant is requesting research outcomes on the various models, and we will do our best to see what kind of materials we have and can send out links to that along with links to the PowerPoints later on this week. But they also have raised immigration issues from any admission of facts related to the drugs, and so kind of what are they? And they also asked about youth and the issue of criminal records and whatever their admissions are very important. And this, when they say youth, they mean young adults and juveniles. If you can speak to either of those two issues.
Well, I'm not an immigration specialist, and so I'm really, what I do know is that pretty much any plea in drug court is going to put you in a bad position in terms of whether or not you can be deported or you'll block your, you can, what's the word I'm looking for? You could, I don't even know the term, but I know that it can keep you from becoming a citizen. So that's, and we do have information on it, but I'm not an expert in this field. I just know if I have an immigration issue, I go get an immigration lawyer, and I ask them to look at whether or not a person can put a plea forth. Sometimes even just going into the program, because there are different rules of immigration. Now, maybe if there is a non-plea, a diversion, that's probably safe, I think, because nothing happens. It doesn't change their status. And regarding juveniles, I think that it would be a juvenile drug court. And I think that the juvenile, whatever the rules are by your state regarding this, it would be very similar to whatever your state rules are related to, it's an adjudication. It's not a conviction in my state. So I think it really that has to be driven by how they treat the juvenile matters in your state. Mike, do you have any view?
Well, pardon me for my prejudice coming through, but there are just basically these arbitrary and seemingly capricious rules by ICE and Homeland Security on what gets you out of the country. I knew at one time it was 4 ounces of marijuana and a conviction. I don't know, like Yvonne, I would go and get the experts, but I do know that it is now incumbent upon us as lawyers, as defense counsel especially, to know, because of Padilla, the immigration consequences of everything, and that would include drug court. So those have to be figured out if that's an issue in the case. I'm just sorry, that's not an issue because nobody wants to immigrate to Oklahoma. They want to immigrate from Oklahoma. So.
I have a little something that I pulled up that I had from something else. Now, this is somebody else's material, but it does state that entering a drug court program may make a lawful permanent resident deportable. That was the word I was thinking of, or ineligible for naturalization.
Would not surprise me based on the amount.
Right. There are steps throughout the drug court process where an immigrant defendant may have to take actions or make decisions that carry the risk of a negative immigration consequence. There's no guarantee that an immigrant can be made safe from the negative immigration consequences of a drug court program. So you know that there are, citizens, if you're not a citizen, you can be deported or removed, and so you don't. If you're trying to solidify your status, you have to be very, very careful about what you can and can't do. I know that, let's see, you can become deportable for a conviction of certain crimes, and so the question is what the underlying crime is that you're pleading guilty to. If the drug court is requiring you to plead guilty, is that underlying crime going to make you deportable?
This is Caroline. I just wanted to add that it's a very, very complex issue, and really have to really be careful, because I know of cases where someone entered a plea and then completed the drug court and the plea was stricken, but because they entered the plea, they had deportation proceedings. So even if they don't go by the ultimate outcome, they go by
that's right.
plea. And so it's a very complex issue.
I agree.
So these convictions, they can affect the defendant's immigration status by making them deportable. So if you go to a trial and you're found not guilty, I guess it does. I don't know. I don't know. I just don't know. But I know that these are real complicated issues. And in fact, in my office, I should say, we had an in-house immigration specialist. Now, I know that everybody doesn't have that, but there are nonprofit organizations that are available that will counsel you. And if I'm sure if your public defender entity or organization should really reach out to some of the nonprofit in New York City. I know there's a couple of big ones, and I'm sure they might have other contacts throughout the United States. So I would reach out to a nonprofit organization that does immigration consequences of the convictions that counsels people on that to see if you can align and have a relationship, to have, training, but even technical assistance, I think you can get that brought in-house. I'm sorry I couldn't answer it more effectively.
Great. And the last question that we have is regarding ethical obligations of communicating sanctions to clients. Sometimes the terms of the treatment plans are not shared with defense counsel, and defense counsel is asked to tell the client to accept the sanction without information of the plan. Can you speak to that?
Say that again. What was the first part?
So it's about the ethical obligation of communicating sanctions to the client. And sometimes the terms of the treatment plan is not shared with defense counsel, but yet defense counsel is asked to tell the client.
The first problem is that you should be informed. What do you mean they don't tell the defense counsel what the treatment plan is? Why? You need to know what the plan is. So you need to know what modality of care, or is your person inpatient, or is it outpatient, what is the plan? So at some level, I understand what treatment will sometimes say is that there's confidential information that the question is, do you have a need to know? The question is, do you have a need to know? There's information that treatment providers will say, this person, they don't really need to know this confidential information, so they may not share that with you. But if it's going to affect you in terms of being sanctioned, you should know what they're being sanctioned for and why. So I guess that to me is in staffing. You should be advocating to find out more specific information so that you are in a position to answer your client. Because to just tell your client, I understand the question because they don't even know how to communicate the information to the client other than the fact that they're told that they're being sanctioned. But you don't really know yourself, so I don't know how you can effectively represent your client without asking for more information, number one. Because it is important that your clients understand why they're being sanctioned. I think that's what the question is.
Yes, great. And you know what, actually, we did just get one more question in. It's regarding staffings on occasions when defense counsel or prosecution, for that matter, cannot attend. What should happen? Should the judge not attend, or should the staffing continue, or should the staffing not be held? What do you suggest?
Oh, now, see, this is a problem. So, Michael, what do you say to this? I have a couple of thoughts, but what do you say? Lots of times prosecutors don't come. Lots of times prosecutors don't come, but prosecutors don't have the same obligation to the client as the defense counsel. So,
I was going to say, here's my belief. It's all right for the defense counsel to be there and the prosecutor not there, but I think it's a real problem for the prosecutor to be there and defense counsel not be there. Does that make sense? Now, I got to say, I participate in things like that, but that's a real problem.
And so they should postpone your staffing if you can be there. I think that if they know that you're going to be away or you're not going to be there, or attorney goes on trial, you have to kind of try to work around this issue. See, what happens is we become a little comfortable and we say this, oh, nothing's going on with my client. Prosecutor, everybody says, supervision says, everything's going on fabulous with Yvonne. No problem. She hasn't had any problems with noncompliance. So people are very comfortable not going, if everything is going well, they have a problem with, they're comfortable with not attending. But what happens is that things do come up that you didn't plan on. So, treatment shows up and says, oh, everything was good this week, but she's really not motivated. Well, that not being motivated, what does that mean? And it kind of snowballs into something else, and then suddenly it's 4 or 5 of those little things. As I said earlier, the little things on the vine. I think that you should do a couple things. Maybe you should talk to your bar association and see if you can get a volunteer. If you cannot afford to have staff attorneys, at least have some coverage for your court. Every defense attorney should have coverage. You can't be there all the time. I totally understand that, but you really have to work hard at your county or your state office has to fund, and they have to be willing to pay for a contract attorney if you need to have somebody else trained in drug court, so at least that you have coverage. Every attorney must have coverage in drug court, and I don't know how else to say it than to, you know, the court has to then, and the county has to put it as a priority. You know, they're saving they're saving money by not having people in prison. Then take some of that money out and give an attorney a contract or sign counsel to support you in the drug court program, or just ask them to reassign it. But I would try my best to be there.
Also, try to be inventive. You know, there was a period of time when my court personnel were strung out, you know, across 1,000 square miles of our county, and we staffed electronically. And this is in the early 2000s. And, you know, the funny thing is there's been some late research, much later than that, that says that use of electronic staffing improves outcomes because it improves the immediacy or the response time of the coordinated response to non-compliant and compliant activity. And so, you know, try to think outside the box in that regard. If you can't all get together at the judge's office an hour beforehand, like is traditionally been done, well, geez, I'll have lunch and just do it in a group chat or Instagram or those other crazy things that happen nowadays that old dad doesn't understand, you know?
Yeah, I agree. I mean, listen, while we're sitting here on this call, we could have very easily had a staffing and had the conversation, and your voice is there, you know what's going on, and you have input into the conversation. I have no problem with, you know, having a virtual conversation, or use Skype if you can't physically be there. Skype in, you know, that's another way to do it.
Great. Well, thank you both. Thank you, Mike and Yvonne, so much for this really informative and dynamic webinar. And thanks, everybody. I mean, it looks like there's still 30 people who stayed on, even though we've gone over 25 minutes.
Please do us a favor. Send us your questions. I think we're going to, there might be a listserv where you could, you know, put your questions into a loop, and myself and other experts will try to help you. Also, I think you're going to post, are you going to post the cases nationally? What's it called? Your your cases of decisions.
Yeah, the case law update. Yeah.
Yes. Yeah, so the case law update, Counsel, right. This is really important. The Carolyn Cooper, the American University has a case law update, and she will post it, and it's broken down by issues. So if you're looking for issues on confidentiality or on due process or on, you know, there's a bunch of different topics. It's either by, and it's by jurisdiction. So it will give you any current case laws in your jurisdiction or in your zone, and that's going to be very helpful to you as well.
Well, Thank you, Carolyn. Jump right on that.
Yeah,
can you announce the next webinar, Yvonne, when that's scheduled?
I don't have my
okay, we have a follow-up one.
I'm sorry.
Okay, Genevieve, because we will have a follow-up. Yeah.
Isn't it May? Is it May? I think.
Yes, the next webinar in the series will be on Wednesday, May 18th, and we will be sending out more information on that. But in the meantime, if you'd like to ask any additional questions or find out more about the interactive listservs that Yvonne just mentioned, please send us an email at justice@american.edu, and we will respond as quickly as we can. So thank you all so much.
And any other questions on other topic areas if you'd like us to cover, please let us know. Thank you. Thank you, Mike.
Thank you all very much. I appreciate it.
Thank you, everyone, for your patience.